What's changing is we're having a whole new system across Europe, or across most of Europe, for patents, patent litigation and the patent granting processes. Probably the most dramatic changes in the patent landscape for the last 30 years in Europe. What it means to you as a patent holder and someone who presumably will be filing patents in the future, if you go down this route, you will be getting one single pan-European patent that will stand or fall across the whole of Europe. But it does come with perhaps a downside for some. That means all eggs in one basket.
There will be a transition period for the first 7 years in which you can choose to opt in your existing patent portfolio into the system, or in which you can choose to not opt in for strategic reasons because, for example, you're not sure how the new system is going to be implemented and you'd rather stick with the existing, more predictable, national-based systems.
Presently, all the countries of the European Union are participating, with the exception of Italy and Spain, but there's an expectation that Italy will join soon and with Spain to follow.
The reason why this has happened now is because there's a real political will that we should have a European patent with unified effect. And if we don't have it now, then we risk not having such a system for another generation.
Well, there's a number of motive forces. One is to reduce the cost of acquiring patents in Europe. If you compare the European Union with the USA, very similar market size, but in the European Union you need to acquire patents in a whole host of different territories if you want to get true pan-European patent protections. Conversely, in the US, you make one application and then that gives you rights across the whole of the United States.
The system by which you will apply for a European patent will not be that dissimilar from the current system in that you can apply centrally to the European Patent Office in Munich, but rather than obtaining a bundle of national monopolies, you will obtain a single monopoly that will cover the EU member states that have signed up to the agreement.
Your existing patents, there's no change. You've still got your basket of national patent rights and they will remain that way. The implications on translations are going to be profound. Historically, if you want to get patents granted in a whole host of different European territories, although you can prosecute the patent in French, English or German, you then need to file local language translations of that patent. That is going to cease. You'll still prosecute your patent in French, English or German, but that will become the definitive document.
Irrespective of the language in which the patent has been filed in, each member state will then have the patent mechanically translated into their own language.
The Unified Patent Court will be one court but sitting in a number of different locations, which will hear disputes pertaining to the unitary patents.
The Unitary Patent Court itself will be made up of local divisions which will be based nationally, or regional divisions which can be shared between 2 or 3 countries. It will also be composed of a central division with its main seat in Paris and also seats in London and Germany. London hearing chemistry and pharmaceutical cases and Germany hearing mechanical engineering cases.
This may sound rather complicated, but I think the complexity arises about sort of deciding which almost courtroom you sit in for to start your case off. But in fact, the theory is whatever courtroom you're sitting in, you're going to get the same quality of judgment, the same law applied, and therefore the same decision. So it is intended to reduce complexity.
I can see a number of problems with the Unitary Patent Court system, and only time will tell whether they actually materialise. For SMEs who choose to file for a European patent with unitary effect, a massive advantage may be a reduction in the renewal fees and simplification of the administration process for filing and prosecuting the patent. But at the same time, there may be increased costs of litigating the patent, and they may not be able to actually enforce their rights. An additional problem might be patent trolls. Patent trolls are companies which apply for patents and obtain those patents, or also just purchase patents from third parties, and then rather than exploiting those inventions, they license the technology or litigate against third parties. So their revenue is obtained through contractual agreements and through litigation rather than actually exploiting the inventions. And a system which is seen by some to be quite patentee friendly might help patent trolls expand their areas of businesses, which would not be necessarily good for business in the European Union.
Ever since the European patent system was formulated in the 70s, there has been a desire to have this single European patent and a single European court for resolving disputes relating to that patent. But it's taken 40 odd years to actually do something about it. Although there's been many attempts along the way, the stumbling block has always been language.
I do believe that overall this is a good thing for the European Union, although there will be a period of time of uncertainty for business, and business doesn't like that. But in the long term, it will be good.
I think one of the more important things you need to decide in the short term when the system starts, which will be presently predicted to be in January 14, although that may slip, is whether you're going to opt in or opt out. For most businesses, I think it'll be a fairly clear opt-in, but you just need to be aware that as the landscape for litigation of European patents becomes easier, therefore you may be on the receiving end of more litigation relating to patents. So maybe not sell quite so close to the mark as historically one may have done in terms of infringing a patent. At Fieldfisher Waterhouse we have a very good track record of bringing proceedings on behalf of patentees and indeed defending other clients from patent infringement actions. Historically we built up that skill set in the UK and in other courts in Europe. Going forward, we're also keeping a very close track on where the new courts are going to be located and in due course the judges of those courts. So we can then best advise our clients on what court they should be trying to bring their case in, the tactical pros and cons of different courts at different times.